if you want to see, you should get closer also. Gotta know who you're sitting with. Everyone clear? See what I'm doing? I'm just breaking it down very simply so we get on the same page. Who are they suing? It says the Turtons filed a lawsuit against the what? County. So it'd be the county that they live in, okay? So that's the defendant. So we've got the plaintiffs who are the Turtons and the defendants are the county. And now let's see what they're suing for. You said they're suing for standing, they're claiming that they have standing to sue in this action, okay? And you said standing to sue means that now we're gonna attach the labels, the plaintiffs or the Turtons believe they've been harmed. And you said, remember, with standing to sue, the harm comes in one of three forms: financial, physical, or emotional. And remember, that harm has to be directly impacting these particular plaintiffs in the defendant. Does that make sense? Okay, that's important. Everyone clear? Because you don't answer the question without knowing what the question's asking. Got it? Step one. Let's go. Step two. What do you have, Lauren? What do you think? Again, keep going louder, please.
I said no just because I didn't have any personal knowledge.
Okay. Eli, do you agree with Lauren? Why or why not?
Yeah, I agree with her.
Well, give me a reason why. That's an easy out, but the quarter and I agree.
Just, they weren't affected.
They what?
Well, they weren't affected by the water.
Okay.
Or
I'm
by
doing some intake.
By the waste. They weren't affected by the waste.
Okay. I'm just guessing on your, are you Chris?
No, Julian.
I'll just go for it. Okay. Who's being pretty much. Julian, what do you think?
I also agree because there was no physical, emotional, or financial harm done to the Turtles.
Okay. Name? Natalia, what do you think?
Well, I said yes because I thought that they had harm because of the trash and like it affected the environment, but now that it's been taken, I'm gonna say no.
Okay, I'm gonna pause and just take these four because we want to dissect. We have a lot of problems to cover. Okay. Got a lot of different ideas going on, and I know whatever you wrote down, you're kind of going through it. It's like, am I a winner? I get this right? Okay. In order to truly understand this, I keep giving you a little bit more to make you think, am I gonna flip my answer or not? Does that make sense? So let's go to it. Okay, if you read, and I don't create and I don't speculate facts. That's a kiss of death, not just in law, but in life. You can't just make believe what's going, I mean, it doesn't work. Your business is all about what's in front of you. Let's figure this out. So here it says, the landfill accepted many kinds of trash. I'm just reading from the fact pattern. I always just read from the facts. The landfill accepted many kinds of trash that, operative word here, right? It says it causes, true? It says it causes harm to the environment, including major appliances, animal carcasses, containers with hazardous content warnings, leaking car batteries, and waste oil. Okay, that's gross. Would you like it if you live next door to that? Do you think that if it causes environment, if whatever's there in the land, if it causes harm to the environment, do you think it could directly cause harm to your lungs that you're breathing this crap? Okay, I do too. Okay, I do too. But they wouldn't have a case, please know this, the Turtons would not be successful if all of this stuff existed before they bought their place. You understand that? So you have to take a look. Let's take it. It says Jack and Maggie Turton bought a house in Jefferson County, Idaho, located directly across the street from a gravel pit. And then the key words here is a few years later. Does that make sense? So they had a home and just an empty gravel pit. Everyone clear? And then it says a few years later, the county converted the pit to a landfill. Okay, so you got a house, you thought, okay, I'm paying a certain X price for a house. Does that make sense? Just on financial alone, do you think that if now that gravel pit is like a waste pit, what do you think the land value, your equity in that house is? You think it's going down, everybody? Yeah. So that is a direct hit. You're good if you just can identify that because you can say they have standing to sue. Does that make sense? But here, you can identify not just financial harm, you can absolutely identify a direct physical harm. Because the threat is imminent, it's present, it's ever present. Just because, for example, if you're breathing like that kind of air and it causes harm to the environment, you don't actually have to wait till you develop cancer or till your ears fall off to say, well, now I know what I was breathing. Does that make sense? The threat's present, it's imminent, it's real. Does that make sense? So here, I don't want you to consider the emotional impact because that's kind of over the scope of where you're at right now. However, it's never going to be just purely emotional, just so you know that. I'm trying to teach you foundation. Everyone clear? So you should be able to get this question right by seriously saying there's a direct physical as well as what a financial harm that has impacted these plaintiffs. Make sense? And that's not based on a hypothetical situation. I'm gonna just pause and give an explanation one more time of what standing sue is. It's so important. Everyone clear? So remember, it's the first foundational requirement that's necessary in order for a plaintiff to establish there's even a reason for them to be in court. Why are the plaintiffs here? Why is this complaint being filed? Does that make sense? You have to be in court because there's some sort of wrong that happened to you. Someone's done something to you, right? So here, the terms of funding, we do have standing to sue. We have a right to be present in this action because what happened to us, it directly impacted us. There was a direct injury. There was a direct wrong. There was a direct harm. It was personal because of exactly what I'm saying. The landfill is we're breathing this crap, okay? I mean, hello, animal carcasses, that's disgusting, you know? So you're breathing this stuff. It's not good. It causes harm to the environment. And our land value, no one's gonna wanna live next door to us. And we spent X amount, and it's gonna go down. And let me just preempt any questions before I ask for questions. It's not gonna tell you that. That's called application. Everyone clear? For those of you that think this class is gonna say, I went to the hospital. Not happening. Everyone clear? Everyone, you understand what I'm getting at? I'm trying to teach you the difference between learning concept and application. We do it all the time in this class. Everyone clear? And we're taking baby steps. This is how you soak your feet into it. See how you actually apply a legal concept to a question. That's all we're doing today. Everyone clear? If you can get to this with learning each concept with application, you'll be very successful as a problem solver. Everyone clear? As well as do very well in this class. But all semester long is all we're doing. Does that make sense? We're just piecing things like this together. I'm gonna pause now. Any questions? And give me your name.
John.
John.
John, I was just wondering, I don't know if it pertains to the question, but would this be like in federal court because it's?
It doesn't pertain to the question, just answer the question. I'm just also gonna tell you this, don't speculate. You know, when someone's asking me to do something, I want the answer to this question. I don't want a bunch of fluff. Answer the question, stick to the question. Got it?
Well, that's because like for my
I know, but
answer.
we're gonna just stick to the question. And what were you gonna say?
Well, just for my answer that I put like, it could be tried in federal court because
Well, it's
it's
not what it's asking
federal
you,
question.
it's not asking you what court. And I'm not gonna answer that question
Yeah.
with this question. Everyone's
That's
clear? Make sense? Answer the question in front of you. There's a specific slice of each fact pattern in each case that has been brought to your attention. And key focus always is answer what is relevant and what is in front of you. You notice, like, if you ever go to court, you know how lawyers go, I don't wanna hear that, answer the question. You know how many times people say that? Okay, I don't know if you ever just have a pulse and watch TV, but they always do it. Because you guys get, when I was practicing, I'd have a witness on stand and go, I'm asking, what color was the light? And they'll go, well, it was a sunny day in Georgia. You know what I mean? I was like, are you kidding me? Just answer the doggone question, I'll slap them. Because the minute you open that door, it's because other things come into play. Everyone clear? You don't want to think like that. Stick to the question. And these are all good questions. Name it.
Sarah.
Sarah. I'm sorry.
So as long as the plaintiff, or as long as
that the plaintiff have experienced some sort of thing, they have standing issue.
You saying as long as the plaintiff does?
Yeah.
Yes, remember, Sarah, standing issue is only about the plaintiff. Like, you're the one who wants to file a lawsuit because you were harmed in some way. That's why you're even in court. You're not in court because, it's pineapples in paradise every day, everything's going your way, and you just won the lotto. You're not there for that. You're in court because why? Someone wronged you. You're the plaintiff. And in order to claim that there's even an attempt for this court to hear your case, you have to at least establish there is a wrong. That is why you're in court. You, as a plaintiff, are establishing that some way, shape, or form, you were harmed, you were wronged, you were hurt, you were injured, whatever word works for you, but that should encompass some sort of physical or financial or emotional harm. Does that make sense?
Yeah,
And it was direct. It's about the plaintiff.
I was wondering because I thought does not like necessarily directly impact like an instant effect on the plaintiff. So I was confused.
Okay, let me help you out. Okay, Sarah, you bought a house, okay? Let's just say you spent $300,000 for a home. Got it? This is you. Feel the plaintiff's pain, people. Always be the plaintiff, okay? So you bought this house. It was $300,000. And next door to your house, it's just an empty lot. Everyone clear? And then that empty lot was owned by the county, the city. Let's just say the city of Long Beach, okay? So you spent $300,000 for your house. The empty lot next door to you, the city owned. And the city decided to make it a garbage, hazardous waste site. They got animal carcasses there, leaking oil batters, just so we all know. I will say this, I can't teach you life experiences. You gotta bring in everything you know for however old you are. So if you don't know that breathing like oil mixed in water, which you should all know what's going on today, oil mixed with water, or like dead carcasses and you're breathing that is gross and it could be major health hazard, I can't teach it to you, you're gonna get it wrong on the test. Do you see what I'm saying? In a law class, you gotta just bring in, I don't know, life experience. I'm teaching you the law, but you gotta blend in half whatever you know in life. And then people go, well, I didn't know that. I go, well, you're gonna get it wrong, and now you know. Everyone clear? So what I'm getting at is if you're breathing that stuff and the words say it actually causes harm to the environment, just common sense, and I'm being sincere here, will tell you now your $300,000 home, which now the city has made into a dump site next to you, do you think your home value is gonna stay at $300,000? No, it's gone down, period. True? And do you think that if you're living next to it, this dump site, and it says it causes harm to the environments because of the pollutants in the air, do you think because you live next door, is there like a magical wall that you can build that stuff doesn't float into your lungs? Does that make sense? So it is direct. Does that make sense? What I'm getting at, Sarah, and I appreciate your question very much, is she's trying to figure out the application without it stating it causes harm. Is that what you're doing? Does this help you? You understand? Do people understand how to get there? Do you get that? And your name?
Aranza.
Aranza.
So in the test, what would be like?
Why are you worried about the test? I'm asking you about this question. You gotta
like,
understand concept.
Why, then the answer to why would be,
On the
like,
test,
was
why are you,
directly-
okay, slow down here. I don't really want you to figure out how my brain works because you're never gonna get there. Everyone clear? Let's just put that on ice. That's not gonna happen, okay? I'm here to teach you the concept. If you understand this, I'm asking, do you have a question regarding the concept? I'm not worried about how I phrase things right now. Do you understand this? And I appreciate you wanting to do well, please know that, but I'm also want you to stay focused in learning. Does that make sense? Everyone clear? Understand that there's only 8 or 9 questions per chapter because it's a mammoth amount of material in one question. Does that make sense? And if you only know the questions we go over with what the examples I give in class and how they are applied, you should be able to do it no matter what. Does that make sense? That's the concept of teaching in this capacity. But I love the questions around that. What would you know what a test book meant? Everyone knows that, okay. Any questions before I get to number 2? Okay, let's get to 2. Alright. Let's. My glasses or my phone, this is not good. Okay, so, there we go. Number 2 reads, Brandy Austin used powdered infant formula manufactured by Nestle USA to feed her infant daughter. Austin claimed that a can of the formula was contaminated with Enterobacteria saccharidi bacteria, causing severe injury to the infant. The bacteria can cause infections of the bloodstream and central nervous system. In particular, meningitis, inflammation of the tissue surrounding the brain or spinal cord. Austin filed an action against Nestle in Hennepin County District Court in Minnesota. Nestle argued for a change of venue because the alleged harm had occurred in South Carolina. Austin is a South Carolina resident and had given birth to her daughter in that state. Okay, what's going on here? Should the case be transferred to a South Carolina venue? Why or why not? Just tell me your name again, right there. You. What's your name? Natalia. I just have to get your names because you've got Lauren, Eli, Julian, Natalia. Behind Natalia, sir. Alessandra. Tell me what venue represents. What is venue? What's that concept? Don't read, just tell me.
As a venue would be like where the court decision is decided, like where the actual court is taking place.
Why? What? Tell me about what that represents, because that wouldn't answer this question if you say that.
So
Do you see what you want to do when you take questions? I'm interrupting because I'm teaching you how to learn. If you go through every single question that I give to you, doing what I'm asking you to do, you don't really have to study for the test. Everyone clear? Because you did your upfront study. That's what I'm requiring of you. For students that want to get A's consistently, that's what it requires. When I ask you to read the chapter, you read it for comprehension. I explain it in lecture. So you should know these concepts. Go back over it, study it, and then try to do the homework without looking at notes. You've studied. Everyone clear? Make sense? Okay, so you're talking about where the case is decided?
It looks like the venue is like change location of the court.
Based on what? Why are you trying to do it? And who's you?
Well, the plaintiff,
No.
or the defendant.
Well, of course, pick that one. I go play, no, I mean defended. When, I mean lost, I mean no.
Like when they feel like that they're being like misrepresented in a way.
No. No, I'm gonna have, sir, are you Chris? You are Chris?
Yeah.
Chris? Okay, Chris, help Alessandro out. Again, please know, I'm super happy, Alessandro, that you've written this down and you're trying. This is all just, please know, open dialogue. All right, Chris, is it Christopher?
Cristobal.
Cristobal, okay,
But you call him Chris, for sure.
whatever you want.
Yeah.
Okay, Chris.
So going based off of what I understood, I just believe it gives the defendant a right for fair and speedy trial.
Okay, what factors do they look at for
Like
venue?
publicity and stuff.
What do you mean publicity?
Like, it's like a major case or something, it's like a big name.
See, I don't feel like you really know it. You're just putting words together, like trying to memorize stuff that I've said. You're being honest.
Yeah.
I appreciate that. In order to answer this question, you need to, if someone's asking me what's your name and where you're from, what you're about, you can talk about it. If I'm asking this question, go, what's venue mean? You're like, oh, publicity, stuff like that. The defendant, people truck. What does that mean? Do you see what I'm getting at? That explains nothing to me. Is it, go for it. Utah, okay, so you've got Cristobal, Alessandro, Natalia, Julian, Eli, Lauren, and we've got Sophia over there. Oh no, I just know your name. Pretty turquoise hair. Okay, Isha, right? Utah. Oh, this is not Idaho, go ahead, Utah.
So we use like the location thing and then.
What about the location thing?
Like,
Explain to me what
yeah,
that
like
means.
there's court, trying, the case should be in a geographic neighborhood where the occurred, the harm, and then, or where the defendant reside.
Okay, you're not explaining at all venue, you're talking somewhat about jurisdiction with a non-comprehensive explanation, but that's not a venue, mister. Next to Utah, your name. Leo, give me your definition of venue. Explain to me what venue is, because you cannot answer this question without a comprehensive understanding about what the problem's asking. See what I'm doing? All right, go ahead.
Where the trial is being held and what state law, what's involved.
No, I'm gonna go back to Aranza.
So venue is, the decision to where the lawsuit is going to be issued based on the defendant's rights.
Keep going. What about the
That's what I
fourth? Okay, we're gonna try to string this together, but we're getting there slowly, putting all of your stuff together. Next to Aranzo is Armando. Can you help her out?
About it, like, they're reiterating everything that I kind of wanted to say.
Well, they're all wrong up to this point,
Okay.
so wanna go for something else? Again, I'm not looking, please know this, all of you will feel embarrassed. Get over it! This is not an embarrassment situation. Literally, this is called true old school learning. You will know how to explain, if you can explain something to me, you get it. Do you understand that? And I'm also teaching you public speaking skills. I don't want you to be afraid to speak in front of others, period. Let go of your attitude. If it's wrong, just accept it's probably gonna be wrong most of the time. Everyone good? There you go. Just let it go. That's good. But with confidence, deliver whatever you have. Everyone clear? So, go ahead. Armando.
Following along with what Aranza said, it's the location where, I guess, depending on the laws, where you were affected.
What does that even mean? Do you understand what I'm getting at? What does that even mean to all of you? It's like, blah, blah, blah. Like, I don't even know. It's like, if this was, if you were watching Peanuts and the instructor up there, it's like, wah, wah, wah. It's like, what? I'm looking at you because it makes no sense to me. You have your hand up. Who had your hand up? And your name, sir?
Joseph.
Joseph. Help them out. Can you help them out, Joe?
Venue is where the county where you filed the lawsuit.
What does that mean? Like, when they're questioning venue, I wanna know, what is it that they're questioning? Explain what venue represents so you can answer the question. If all of you are saying, it's where the county is, the defendant's right. What does that all mean? How do you figure this question out? Again, Riley,
It's the appropriate location for a trial,
based on what?
the jurisdiction of.
No. All right, I'm gonna go for two more. We'll go with, is it Isaac? No. Is it right? Isaac? Okay, Isaac, and then we'll go with John, because you're gonna, and then I'm gonna have to help you out here, so we gotta move on. Go ahead.
Location best suited for a fair and speedy trial,
Which means what?
which means it's the most appropriate for.
Why? Like, how do you want fair and speedy trial? What are you
The
talking about?
defendant wants to have a fair and speedy trial.
As every defendant?
And so the question of venue comes up, saying, we want to have a fair and speedy trial in a certain location because this is the best suited place, like making it as fair as possible, so that justice.
That's true. Okay, I want you to digest how you'd apply. John, how do you apply that? Explain it.
Yeah, what I was gonna, what I had in my mind was like if it's like a small town situation where, it's just not deemed fair for the defendant to be tried in there.
Okay, what things do they look at when you talk about fairness of people? Do you see what I'm getting at?
Yeah.
I want you to like put it in your head. So you guys are all getting there, but you're not hitting the bullseye. Sir, your name.
Jose,
Jose, what do you think?
so I'm assuming that Nestle did their
First of all,
research.
don't ever say assume.
Yes.
You never want assumptions
Okay,
anymore. Just go.
so
This-
based off the current information given to us,
Okay.
Nestle, the defendant,
Okay.
did their research and they looked at did the cause of action happen in this area that they're suing?
and then they did, does the defendant reside in that area? And if you look right there, it says Austin is a South Carolina resident, and he had given birth to the daughter in their state. So that's already like two.
Are you repeating facts? I want to just know
I think so.
definition of venue.
Oh,
That's all I'm
yeah.
asking.
I don't know. Next.
Okay. You got my interest. Go, Sarah.
If the court finds that there's a huge possibility that the defendant would not have a fair trial in that state because the citizens of that state is prejudiced or have a prejudice against that defendant.
And it could be, yours is the most comprehensive up to this point. You're saying, bottom line, people, when you read a venue, there's a question about venue, you're going to say, why is the defendant opposing this location where, listen carefully, jurisdictionally you can go to trial here. The plaintiffs can sue in Minnesota, okay? They can, okay? And I'll explain why. But why are the defendants opposing venue? Even if everything jurisdictionally is proper in the particular place, a defendant can say, hold it, not so fast. I think I'm going to have a prejudicial action against me. I'm not going to have a right to a fair and speedy trial because of the bad publicity or media. I will not be able to get a fair jury because of factors outside my control have already likely have determined my innocence or guilt. My guilt at this point. Here, do you see what I'm saying? You got to know that to answer it. Like, that's venue. What kind of, why is a defendant, when a question's asked me like that, you got to think in your head, why is the defendant making such a big stink here to go to, to oppose it? You got to go, because they're going to say, if it's a venue question, they're saying they feel prejudiced here for certain reasons. Does that make sense? Even though jurisdictionally, and that's important to understand, it can be tried where the plaintiffs have filed a lawsuit, they still think it should be moved to a particular location where it's more fair for them because of the prejudice against them based on certain factors, and let's look into those factors right now. Does this make sense? Like, what I'm trying to get you to do is you'll never be able to get questions right in this course if you don't know what the problem's asking. It forces you to, because everyone's like, so you can test, for example, a round, so you ask a question, put a question out there, you don't even know what the question's asking, but you go, I got it wrong, can't believe I got it wrong. Like, huh? If you come to my office and explain to me what that question is, and then you can't, I go, what the heck do you think you're gonna do? You're in Vegas on a test. Everyone clear? Got it? And believe me, there's no winners in Vegas. You understand that? Okay. So let's take a look. Okay, you got Austin. Austin's, they're suing because they gave this baby formula to their baby infant who got some meningitis. Everyone clear? And it also says that the defendants, which is Nestle, their principal place of business for this Nestle Corporation is in Minnesota. Everyone clear? So we know this. Number one, let's just break this down. Is standing to sue do they have, the Austins have standing to sue? Yes, they're suing on behalf of their baby that got meningitis. Everyone, there's direct physical harm, we can see that. Everyone clear? So they're standing to sue. Check. Does the Minnesota court, listen to what I'm asking, have jurisdiction, which is the power to speak the law, over Nestle? Which is, does this Minnesota court? Well, if the defendant resides, the principal place of business is in Minnesota, you automatically have personal jurisdiction over this defendant. Does that make sense? Or also they're a corporate defendant that sell their products everywhere, but they made it really obvious here. It's their principal place of business. Remember, jurisdiction over the defendant can be acquired in a couple of ways. You can sue where the defendant resides or where the cause of action happened. Automatically, either one will warrant what we call personal jurisdiction. Does that make sense? And again, you got to get into it to figure this out. Again, this is not a property case, okay? This is not about real property, so we don't have to worry about that, because remember, if you did file a lawsuit based on real property, the action would be viable or right to be sued where the property is located, but we're not worried about that. You could also automatically get personal jurisdiction based on corporate defendant, but you don't have to go that route, placing their products into the stream of commerce because their principal place of business is there. Does that make sense? So you have jurisdiction over the defendant. Check. We're assuming that the subject matter is viable, we have to go right to venue now. So even though jurisdiction is proper in Minnesota, Nestle's like, no. We want to oppose being tried as a defendant in Minnesota. My question to you, class, is, it says, should the case be transferred to South Carolina venue? I'm gonna give you the right answer, you tell me why, okay? Yes, absolutely. Got it? Now I'm gonna ask you why. Whatever you have written down, get rid of it and figure it out. Everyone clear? That's what you did. So, in front, next to Joseph is, what is your name, sir? Merlin. Why should it be transferred to South Carolina?
It should be transferred to South Carolina because the plaintiff would be a more fair trial.
It's all about defendants' rights. Tell me why. Why are you talking about the plaintiff right now?
Because like, plaintiff would have a better trial and it'd just be less prejudice.
But you can't just throw those words out. You'll never get it right on the test. You understand that? I'm all about substance, people. Why? I'm just having Merlin absorb that. Please know I raise my voice all day long, okay? It's not because I'm mad at you. I'm also trying to wake you up because this is a tough class. I'm a student, and the only reason I stayed awake is because of my loud voice. Anyway, Joseph, what do you think? Give it a shot. Why should this be transferred to South Carolina based on the venue? You now know what venue is. So tell me why, Joseph. I feel that you're going to get this right.
I was kind of going to say the same thing.
Well then, I was wrong. Okay. All right, I'm just going to go there. Here we go. Why do you think this major corporate defendant wants to transfer it? Because they don't want to look like they're schmucks. Let's be real. It's like the plaintiff's attorney's like, ooh, let's make him look really bad and evil. You already got a kid with meningitis, probably sick for the rest of their lives. Why don't we make you take your sick baby from South Carolina, where you live, where the accident happened, and go to Minnesota with people that are like, why would you take your sick baby with all this and travel all the way to Minnesota for this case? These big, awful defendants. Does that make sense? They're already screwed. This is reality. Let's minimize, it's called mitigate damages. This is what you do as a defense. I'm like, heck no, HE to the double hockey sticks, we're not going to Minnesota. I'm going to make you look. They're the baby business formula company. They're for goodness. It's like, let's make it as comfortable as possible for the plaintiffs to litigate the case here, which is not transferring them and their baby with meningitis to Minnesota for a case. Do you understand that? Yes or no? Cause of action happened there. This is what plaintiffs' attorneys do. They want to make you feel like a plant. They want to maximize and get you. Defense like, no, we're opposed to venue. Because if you're trying to make us look bad in Minnesota, we're not going to get a fair trial because this is ridiculous. The cause of action happened in South Carolina. You guys live in South Carolina. We have our products in South Carolina. This is the proper place to go because we look like we're bad people that are forcing you to travel and do all this just to sue us. That's ridiculous. Do you see how that works? You can't get there, folks, unless you know venue. You understand that? Yes or no? Are you starting to see application in this class? It's going to all day long. You will never do well if you just try to memorize stuff. Everyone clear? You see what I'm getting at? What is the only thing that's been consistent so far? A concept. Standard sue is never going to change as to what it means. Venue is never going to change. Jurisdiction is going to change. What changes? Facts. Does that make sense? But you can't get a conclusion or the right result without knowing what the concept is and then applying it. It's, I just sincerely tell you this, it's actually less study, living your life, understanding how to absorb information. I always laugh when people go, and believe me, it's so funny, they're like, oh, you're just smart because you know this. I'm like, I just think that's such an overrated term. I'm disciplined and I have common sense. Take a concept, know it, and apply it. I'm like, I'm glad you think that's being smart. It's just called being, I don't know, I don't have problem solving. And then I think it's so basic that unfortunately so many students today don't realize they have that superpower. Everyone clear? all of you have that superpower, but so many people do not utilize it. It's so sad. Because in life, your brain is the most beautiful organ in your body, seriously, and we still don't know how much it can do. It's limitless. But so many people, it's like if you don't ride your bike for a long time, it gets rusted. You don't use something, you don't practice it and you think about it, you don't use that organ a lot, whatever it is, whatever it is. There's dust on it. Everyone clear? It doesn't work as effectively. If you use something all the time, you're doing it, you know what I mean? It's going, it's thinking. Think about that with your brain, okay? I just really want to get you healthy habits of forming how to get to being a strong problem solver. All right, let's go to 3. Any questions? Jillian?
Yeah, so when it comes to venue, it will always be up to the court.
I never want the always, just ask the
Oh,
question.
okay. Well, it's up to the court to decide whether it's appropriate to switch the venue,
Correct, it's the court, the defendants, they're writing this venue objection, and it's the court that's deciding, yes. Any other questions? With problem 1 or 2? Okay, let's move on to 3. Are you starting to understand why homework is an important day? Got it? Thank you, Warren. Who else is sitting there? Okay, all right, let's take a look at number 3. I'm gonna take this, there's a couple I'll just take myself because we still have a lot to do, and I wanna make sure you get through. Okay, it reads, PRM Energy Systems owns patent license to Prime Energy to use in the United States. Their contract stated that all disputes would be settled by arbitration. Kobe Steel Japan was interested in using the technology represented by PRM's patents. Prime Energy agreed to let Kobe use the technology in Japan without telling Prime Energy when PRM learned about the secret deal, the firm filed a suit against Prime Energy for fraud and theft. Does this dispute go to arbitration or to trial and why? And I'm gonna just take this question because this is very simple, this little hint. You want these questions on a test because the rule regarding arbitration is simple. If your contract says go to arbitration, what do we do, class? Thank you, that's it. It's so simple, you're always like, it seems so complicated because they get you to read Prime Energy, what the heck's going on, all the different names, you're like, question, should it go to arbitration? And it says all disputes go to arbitration. The answer is always gonna be yes. Remember though, if you go to an arbitration and you believe that for some reason it was unconscionable, one-sided, there's some issue, misrepresentation there, then you can file a lawsuit in the court of law. But the whole purpose behind language or any type of contracts that tell you that if you have a dispute in this particular area to go to an arbitration is because typically the arbitration will settle the matter without wasting a bunch of time and money. Everyone clear? But if for some reason, it's whatever your issue is with it, you always have a right to then file a lawsuit. Does that make sense? Any questions? Number 4. Yeah, a whole If you're ever bad, you have to sick. Okay. Number 4. Bruce Matthews played football for the Tennessee Titans. As part of his contract, here we go, folks, he agreed to submit any dispute to arbitration. He also agreed that Tennessee law would determine all matters related to workers' compensation. After Matthews retired, he filed workers' compensation claim in California. The arbitrator ruled that Matthew could pursue his claim in California, but only under Tennessee law. Should this award be set aside? Explain. I'm gonna know this one too. This is another one. Okay, it says go to arbitration, you're gonna use Tennessee law, do it. Everyone clear? Follow whatever the arbitration rules are. You don't like it, file a lawsuit. Does that make sense? Got it? These are like those delicious give-me's if I give them to you on a text. And you're like, just go to arbitration, people. Got it? Yes.
Okay, well, when I did the question, I thought it was only when you played football, the arbitration first contract. Because it says after he retired, he did it regularly.
It is the workers' compensation for the football. It's about his football playing career. That's where you get workers' compensation from the work you did. It's just, well, I'm just telling you, I'm just trying to help you out here. Okay, workers' compensation is money that you get from work-related injuries. That's what it's for. And it's, he played for the Titans, and it's any dispute regarding whatever his football career stuff, I don't know, and I'm not speculating, because I don't care. Everyone clear? Does that make sense? You're trying to think, oh, I think it's for this or that. I don't really care if this is what it's saying. He works for the Titans, he's filing for workers' comp with the Titans. To me, that's a work-related injury. It says, you gotta use Tennessee law, arbitration, do it, you don't like it, file a lawsuit. Everyone clear? It's that simple. At this level. Everyone clear? Okay. Okay. And it's very easy to get distracted with, like, when you read a question. Like, in a lot of these questions, a lot of students get distracted just by trying to get through the reading of the question because they have all the different people's names and stuff. Like, I just want to think of something. When you're taking law exams or you read contracts, like Enterococci-bacteria, are you kidding me? You could spend like a minute trying to figure out what that word means. I just go disease X. Do you see what I mean in my head? I'm just letting you know how to superficially get through stuff with getting the meat of something. You got X disease from this. Does that make sense? I very much, I'm just sharing what I do. I don't know if it's right or wrong, but it's worked for me for life. Everyone clear? Because you need to get through something, and on a test, you can't be hung up on, how do you pronounce this guy's name? It's a joke. Like in court, like it was so funny, because I would literally learn all the way up to trial. It's, a lot of people have very interesting, like even in this class, I have a hard time like knowing how to pronounce everyone's names. And you don't wanna like be disrespectful in court, but like if someone's name is, I don't know, even like just say Sophia, and I couldn't pronounce it, I put S, Miss S. Do you see what I'm saying? But then in court, I'm like, the day before court, I was like, or a couple days, I'm like, what's this person's real name? You know what I mean? And then I had to articulate how to say it. But it was nice, I would say, please know, based on, I don't wanna be disrespectful, I will just use your first acronym. I would say that. But it helps people get through complicated material. Does that make sense? So do that for yourself. Something to help you guys. Okay, let's look at number 5. Seal Polymer Industries sold 2 freight containers of latex gloves to MedExpress Inc., a company based in North Carolina. Okay? When MedExpress failed to pay the $104,000 owed for the gloves, Seal Polymer sued in an Illinois court and obtained a judgment against MedExpress. MedExpress argued that it did not have minimum contacts with Illinois because it was incorporated under North Carolina law and had its principal place of business in North Carolina. Therefore, the Illinois judgment based on keywords here, personal jurisdiction was invalid. Was this argument, keyword here, alone sufficient to prevent the Illinois judgment from being collected against MedExpress in North Carolina? Why or why not? Okay, let's dissect this question. In front of John, sir, what is your name? Matthew. Explain to me how you can obtain personal jurisdiction if you're a court. Again, use your hall voice.
You can obtain jurisdiction if the defendant had contact in the area, in your area, we want to sue.
Let me be more restrictive with my question. What is the most simple and quick way for a court to obtain personal jurisdiction over a defendant?
I'm not sure.
Okay. Isaac, give him a hand.
First one, well, I mean, questions, minimum contact.
I'm
Okay,
not-
yeah, I wasn't
answered your
ready, I
question.
wasn't ready.
There's a question pending.
Okay. No. not on this judgment alone.
Does that even make sense? I'm
That's
asking you how to, what?
Could you restate the question, please? I'm sorry.
Yes. I was like, what?
I was.
How do you obtain well, you can't. Like, what is the quickest way for a defendant to obtain personal, for a court to obtain personal jurisdiction over a defendant? Because you can't answer again. Do you see what I'm doing? You can't answer the question without knowing what the question's trying to ask. Do you want an assist from Emily?
Yes, please.
The quickest way to get personal jurisdiction is, if
For a court to
for a
obtain.
court to obtain personal jurisdiction, the defendant has to either reside there or the situation,
Cause of action.
the cause of action occurred in that.
Perfect. Does that make sense, everybody? So, quickest way for a court to have the authority to speak the law, which is jurisdiction over the defendant, the quickest way is through personal jurisdiction. That's if the defendant resides within the area or the cause of action happened there. Got it? Okay. So, then again, if you're a corporate defendant, please know if you place your products into the stream of commerce in any of the 50 states, you're a right to be sued then, okay? Because you can obtain through the law and arbitration, automatically you get personal, through the minimum context, you get personal jurisdiction. This is not a real property case. Everyone clear? So let's go back to the question. It says, was this argument alone sufficient to prevent the Illinois judgment from being collected against MedExpress in North Carolina? Okay, MedExpress is let's see, MedExpress argued that it did not have minimum context with Illinois. They're the defendants, okay? You got Steele Palmer, the plaintiffs, and MedExpress is arguing, hey, I have no minimum context with Illinois because my principal place of business is what? North Carolina. And they go, I don't know. Why are you suing me in flipping Illinois is what they're saying. Everyone clear? And then the question is, was this argument alone sufficient to prevent the Illinois judgment from being collected against MedExpress in North Carolina? I hope you will answer no, Isaac, because you know why? Because just based on the principal place of business, that's not the only factor. Does that make sense? So your answer would be, well, if your principal place of business is in North Carolina, you may not have that to establish personal jurisdiction, but there's more questions that we need to address. Where did you send the product? Did you send it to Illinois? Does that make sense? Do you distribute the product in the 50 states? Which means you automatically get minimum context and personal jurisdiction. There's other questions that need to be addressed in order to say there was no personal jurisdiction in Illinois. So when it says, was this argument keyword alone sufficient to prevent the Illinois judgment from being collected against MedExpress in North Carolina? You're gonna say no, because there's more questions to address, because there's other ways to obtain personal jurisdiction. Does that make sense? You see how you have to get there? You have to know the concept very intimately in order to answer questions. And that's study of the concept. And for those of you that didn't get any of these questions right, that's okay. Go back and study what we're talking about. That is how you do well on an exam. Does that make sense? I'm equipping, I'm trying to like get you equipped with all the tools to be successful, not just in this class, but you do this type of assessment in any class of study, you're gonna be an A student. Okay? I'm sincere. It took me a while for me to just not be so lazy in school, okay? Out of the gun, I wasn't a straight A student, okay? I was lazy, and that's the biggest problem most students have. And then I got my crap together. I was like, I couldn't help but get A's. I was like, okay, this isn't too bad, okay? But you have to invest in it. You have to invest in the time it takes to learn. That doesn't come overnight. Make sense? Any questions with this question? Let's keep going. Oh, we got another. Okay. I'm just gonna, sorry, switch on you. All right, it says, number 6, Horton Automatics and the Industrial Division of the Communications Workers of America, the union that represented Horton's workers, negotiated a collective bargaining agreement. If an employee's discharge for a workplace rule violation was submitted to arbitration, The agreement limited the arbitrator to determining whether the rule was reasonable and whether the employee had violated it. When Horton discharged employee Urban de la Garza, the union appealed to arbitration. The arbitrator found that de la Garza had violated a reasonable safety rule, but was not totally convinced that Horton should have treated the violation more seriously than other rule violations. The arbitrator ordered de la Garza reinstated. Can a court set aside this order? Flynn, again, I'm gonna handle the arbitration motions here. It's just, yes, you have to file a lawsuit. Does that make sense? It just, what I want, what they're trying to express to you, when contracts tell you to go to arbitration, it is trying to resolve that matter with people that know those type of specific disputes without wasting time and money to go to court. But when someone doesn't rule properly, obviously, you have your right to go to court and have that court, another court, set aside this particular decision. Does that make sense? Any questions? John?
Does the arbitrator like breach his power too? Because
Everyone can try to reach their power, and many people do. You gotta know the rules of law, so you don't have to get away with it. Make sense? It's life. People are human and not nice. Honestly. I want to sum this out, goes through this year. All right, number 7. LG Electronics Inc., a South Korean company, and 19 other foreign companies participated in the global market for cathode ray tube CRT products. CRTs were integrated as components in consumer goods, including television sets, and were sold for many years in high volume in the United States, including the state of Washington. The state filed a suit in a Washington state court against LG and the others, alleging conspiracy to raise prices and set production levels in the market for CRTs in violation of state consumer protection statute. The defendants filed a motion to dismiss the suit for lack of personal jurisdiction. Should this motion be granted, explain. Well, I think we can answer this because we know next to Isaac is who?
Joseph.
Okay, what is personal jurisdiction? Explain it before you answer this question. And how do you obtain it?
From Emily, I got that.
Give a little props up, Emily, I like it.
If you, it's a harm that causes if you reside in, like, you have a right to.
Let's tighten that up, shall we? Because that's not what Emily said. You're doing a disservice to her beautiful explanation. Okay, your name again?
Joseph.
There's 2 Josephs, okay. Right? You're Joseph 2?
Yeah.
You could be Joseph 1. Sorry. Okay, let's see. What is your name? You right there.
Me?
Mhm.
Amanda.
Amanda. Know when I'm staring at you, it's so funny, you're like, she's not looking at me. I'm like, I'm looking at you, okay? Amanda, explain to me how a court can obtain personal jurisdiction. Kind of do Emily's explanation justice, shall we?
They can obtain personal jurisdiction if that's where the defendant resides or where the incident happened.
Okay, remember when you say they, it's the court. The court is the one
Yeah.
that wants to have the power to speak the law, which is jurisdiction over the defendant. Okay, easy enough here. And, gosh, is it Amanda?
Yeah.
A lot of A's in this class. You got Alonzo, Armando, right? Just trying to look at your name. Sorry, this is what I do for intakes. I will know your names next week. Okay. Amanda. Give me another way, if you're a corporate defendant who places your products in the stream of commerce in any of the 50 states, is that another way through minimum context to obtain personal jurisdiction?
Yes, if they have their
Okay.
product in that.
Okay, so you tell me that. It says the defendants filed a motion to dismiss the suit for lack of personal jurisdiction. Should this motion be granted in this way?
The defendant filed a motion to dismiss the suit for lack of personal. No, it should not be.
Because why?
Because they have their product there, so
Yeah.
it's a minimum
Does
contact.
that make sense? Because they place your product in the state of Washington. The bottom line, you're placing your product in that state, you automatically can establish the long-arm statute because it's a corporate defendant,
Mhm.
minimum context, where you get personal jurisdiction. Does that make sense? Yes or no?
Yes.
Excellent. Last but not least, I'm gonna have to hop around here. All right, let's take a look. It says, Angelica Westbrook was employed as a collector for Franklin Collection Service. During a collection call, Westbrook told a debtor that a $15 processing fee was an interest charge. This violated company policy. Westbrook was fired. She filed a claim for unemployment benefits, which the Mississippi Department of Employment Security approved. Franklin objected at an MDES hearing. Franklin's supervisor testified that she had heard Westbrook make a false statement, although she admitted that there had been no similar incidents with Westbrook. Westbrook denied making the statement, but added that if she had said it, she did not remember it. The agency found that Franklin's reason for terminating Westbrook did not amount to the misconduct required to disqualify her for benefits and uphold the approval. Franklin appealed to a state intermediate appellate court. Is the court likely to uphold the agency's findings of fact? Explain. Sophia, what is a finding of fact? If you're gonna, first of all, let's go back. What's an appeal, Sophia? What does it mean?
Reviewing court.
Yeah, say it louder, you're right. Get a decision reviewed by another court, okay? Don't feel bad, even if you say, honestly, if you said it's for hamburgers and fries and you say it with confidence, I'm gonna believe you. Does that make sense? Say it with confidence. Okay, so an appeal means you wanna send it to another court to review that decision. Now, let me ask you, when you appeal your decision based on a finding of fact, what does that mean and what is generally and most probably likely to happen?
I don't know.
Okay, fair. In front of Amanda, sir with the red hat, what is your name?
Tony,
Tony. What is a finding of fact?
finding a fact.
Are you trying to find yourself right now? You sure
I know
look
you're-
like it. You're like, oh my God.
I don't even know. It's like, are you trying to like get to know a fact? That's what I
Tony,
think.
you know what I appreciate about you? Like, I have no clue what this chick's talking about, whatever. Just say something. Okay. Let's just, no, because we're running out of time. I would love to play games with you right now, but I can't. Okay, so, Jose, right?
Yeah.
What's a finding of fact? Can it pass?
I'm with him on this one.
Okay, I can feel your vibe together, both of you. Jeremiah, finding of fact, what is it?
Finding of facts are just the facts in the case, like, there's no, I'm not saying there was an issue with how the case was tried itself. The finding of fact is simply the facts in the case. and saying
Okay,
whether or not-
and tell me, what does a juror refer to? As a fact finder, right? So typically, if you send an appeal based on findings of fact to another court, is it likely to be granted, Jeremiah?
No.
Because it's right. Now listen, he's right. The facts are what people say in the case. Everyone clear? Jury makes a decision. It's based on the evidence presented, not on the law. Everyone clear? As a result, juries may tend to differ. If you actually base your appeal on a finding of fact where you think you don't like how someone else decided this on that based on what was introduced, based on saying, well, I don't think you made this false statement, this is like a testimony. Does that make sense? You're stuck with it, sorry. Okay? Typically, that court is not going to be able to grant the appeal. Does that make sense? But let's finish it. Also know that if you base your appeal on a question of fact, and it's something that happened about some evidence that was presented, listen carefully, where no reasonable jury would have come up with a decision based on the evidence presented, because it defies what's reasonable, then you can have your appeal granted. But let's comprehensively learn appeals. Most appeals are going to be granted if you submit your appeal based on a proper question of law. Okay, what that indicates is that something which is not in the plaintiff or the defendant's authority, but something in the management of your legal case itself was erroneous or mishandled or some negligence, or it can be purposeful. The bottom line is it has nothing to do with the actual facts of the case. but it has everything to do with how the court handles your case. If something was at a loss, or was, I don't know, erroneous again, you can base your appeal based on a proper question of law, and those are generally granted. Everyone clear? So that's a big difference here.
So if it-
Riley?
Thank you. If it is granted and the court finds that there's merit behind questioning the fact, then a new jury will be reinstated?
Remember what I said about appeals. The appellate court has broad discretion to do whatever they want. Does that make sense?
Yeah.
So you just have to know that. They could remand the case, which is send it back down for a new trial. If it's a mistrial, you do get a new juror, so it just really depends on what the appellate court decides. Sarah?
So most appeals based on, question of fact is most likely
Denied.
right?
Correct. Okay, any questions here? Okay, well, I'm gonna start with you two next time, okay? So you get to hear from you. All right, we got a minute, and I'm gonna use it, sorry, people, that's what happens. Are you starting to see how to do this, okay? It's a meaningful process, but the students that actually did their homework will gain a lot from it. Does that make sense? And I know who you are that didn't try or mentally looked at it and I didn't see you looking with your whatever. Here's what I want to say. You will not grasp the application unless you practice it yourself. Everyone clear? So I genuinely want to tell you to do well. I want you to go over these problems and how we got there. Everyone clear? And we covered a lot of the law in this chapter. And you have to do that in order to know how to apply. So please take it upon yourself to review chapter 2. And again, superficially read chapter 3, but try to read the first couple pages in chapter 6. You want to make the scene and the chapter.